വിദ്യാർത്ഥിനിക്ക് പൊതുവേദിയിൽ വിലക്കേർപ്പെടുത്തിയ സമസ്തയെ വിമർശിച്ച ജസ്റ്റിസ് കെ ചന്ദ്രു സ്ത്രീകളോട് വിവേചനപരമായി പെരുമാറാൻ ഒരു സാമുദായിക നേതാവിനും അവകാശമില്ല. സമൂഹത്തിൽ ലിംഗസമത്വവും സ്ത്രീ സംരക്ഷണവും ഉറപ്പാക്കണം. സമസ്താവേദിയിൽ പെൺകുട്ടിക്ക് വിലക്ക് ഏർപ്പെടുത്തിയ നടപടി ശക്തമായി അപലപിക്കാൻ സമൂഹം തയ്യാറാകണമെന്നും ജസ്റ്റിസ് ചന്ദ്രു ന്യൂസ് 18നോട് പറഞ്ഞു. രാജ്യദ്രോഹ നിയമം മാത്രമല്ല UAPA അടക്കമുള്ള കരിനിയമങ്ങളും റദ്ദാക്കണം. കർണാടക BJP വിദ്വേഷം പരത്താനുള്ള പരീക്ഷണശാലയായി ഉപയോഗിക്കുകയാണ് എന്നും ഹിജാബ് നിരോധനം ചൂണ്ടിക്കാട്ടി ജസ്റ്റിസ് കെ ചന്ദ്രു വിമർശിച്ചു. SS ശരണിന്റെ റിപ്പോർട്ടിലേക്ക്.
തമിഴ് സിനിമയായ ജയ് ഭീം പുറത്തിറങ്ങിയതിന് പിന്നാലെ ലോകശ്രദ്ധ ആർജിച്ച വ്യക്തിത്വമാണ് ജസ്റ്റിസ് കെ ചന്ദ്രു. ജസ്റ്റിസ് കെ ചന്ദ്രു തിരുവനന്തപുരത്തെ ഒരു പരിപാടിയിൽ പങ്കെടുക്കാനായി എത്തിയിരിക്കുകയാണ്. ഏതായാലും അദ്ദേഹത്തോട് സമീപകാലത്ത് ഉണ്ടായ വിഷയങ്ങൾ നമുക്ക് പ്രതികരണം തേടാം. സർ, മലപ്പുറത്ത് ഉണ്ടായ സംഭവം സാറിന്റെ ശ്രദ്ധയിൽപ്പെട്ടിട്ടുണ്ടാവും. അതായത് സമസ്ത വേദിയിൽ സമസ്ത നേതാവ് പെൺകുട്ടിക്ക് വിലക്ക് ഏർപ്പെടുത്തുന്നു. ഇതിനെങ്ങനെയാണ് സർ കാണുന്നത്?
Constitution gives equality and equal protection law irrespective of gender, and Article 15(2) prohibits any kind of discrimination against women. And there is a fundamental duty under 51A which says all obscurantic practices against women must be shed. If these are all the constitutional right and the constitutional duty, I do not think any political leader or any religious leader can say that women are only to be kept at home and cannot come out in the open. It's all a wrong thing. It's an obscurantic idea which is have no sanction in law. And secondly, gender justice is an underlying principle in this country, and nobody can put women in the backyard. And I don't think there is any religious sanction behind it. Even if there is, the Constitution is a paramount document which overrides all other obscurantic ideas.
Here the governor says a case should be registered against the Samastha leader. How do you reply to that?
Merely because expressing views, if you start putting people, there are crores of people in this country who have similar views. So what is required is the other people who must come out strongly to condemn such practices and support women to come forward to participate in public life. That's the only way. It requires a public censure rather than criminalizing people, because there are similar views are held by them. Even some women have such views also. You don't pounce on such people, but it's too late for them to say such things in the teeth of constitutional provisions.
Sir, recently Karnataka High Court banned hijab in the schools. Actually, there's a right to education. So, how do you look into the verdict?
Actually, it has nothing to do with the High Court. It is a BJP government which wants to bring new rules so that they can isolate people on the basis of religion. So suddenly they made a uniform law which did not prescribe hijab as a permissible attire. Now, when they bring the law, that was challenged in court, and a full bench of the Karnataka court held it's valid. Now matter is in Supreme Court. Supreme Court did not grant stay. The result is number of girls could not go to school, and the statistics show there are 20,000 girls who have not written 10th standard examination. Now this is such a foolish thing, because one is religious ideas being used to split people, to bring hatred, cannot be allowed. Now BJP uses Karnataka as a laboratory to experiment on this hate politics so that they can expand to the other southern states. I do not think their tactics will survive or succeed in Kerala or in Tamil Nadu. They are more advanced state. And when there is a right to education, which is a fundamental right, the girls will have to be in school. Whatever dress they wear is irrelevant. You cannot, in the name of uniform, prevent girls from coming to school.
So you think there is a conspiracy behind the decision?
It is a BJP experimentary laboratory. Unfortunately, the Supreme Court could not decide faster, and the full bench judgment of the Kerala High Court is fully wrong. It's not consistent with the Constitution.
Recently, Supreme Court raised so many questions regarding sedition law, and court revoked the sedition law.
Government wanted to have time to relook on the matter. I do not understand what is the word relook, but court wanted to adjourn the matter by giving time. This is what government wanted. Now government can decide, we want the law. Then the court will have to hear the main case. Government may decide, we do not want the law. Then the court case is failure. Government may amend the law much more sinister then again we'll have to have a fresh challenge. I think this is the entire thing is only sidetracking the main issue. Subsequent to the Indian Penal Code, there are several criminal laws which are much worse than this. UAPA Act, Unlawful Activities Prevention Act, is one example where people can be detained without bail. People can be sent to jail without even charge sheet being filed eternally. Now even in the Bhima Goregan case, 13 people are inside. Now instead of fighting for repeal of all black laws, getting joy over 124A limited stay is not a correct thing. Ultimately, 124A stays or not, there are much worse criminal laws in India. We'll have to seek for repeal of those laws.
There are a lot of cases pending in the courts. How this is going to affect the proceedings?
Now, pendency of cases and backlog is another worrying factor because all over India there are 4.41 million cases are pending. Supreme Court 72,000 cases are pending. Now, pendency has a different dimension. Now, some people are saying increase the number of judges, it will get reduced, it will not get reduced. We will have to find ways and means by which the pendency can be reduced so that quick justice, timely justice will be given to people. Instead of giving timely justice, you are only thinking of artificial solutions. Artificial solutions will not bring down. For example, in my tenure as a judge for 6 years and 7 months, I was able to dispose of 96,000 cases. Nobody has ever asked me, how did you do it? Because they are not interested at all. Everybody is interested in their office and then the perks attached to the office, but not the fundamental issue. Why? One simple example. The court work only half the year only. 185 days, 200 days they work. The rest of the days go on holiday. Now 2 years the courts were closed due to pandemic. They are still having a summer vacation now. Well, already you had enjoyed vacation enough. Why can't they work during the vacation? They are not interested in giving up their own perks, their own enjoyment of vacation. Now, if you say you work more, they say we are too tired, we are working very hard. If you are working hard, why is there so much pendency? Therefore, there are the experts on this field will have to discuss and find ways and means to reduce the pendency. And you must appoint quality judges, not all kinds of judges on irrelevant consideration. Therefore, there are so many other suggestions have come from many expert committees, but they are not looking into those committees.
Thank you so much, sir, for joining with us.
Bye.